So we have Professor Camilla Baasch Andersen from our UWA School of Law, and she's going to talk to us about comic book contracting. Please welcome Camilla.
Thank you. It's an absolute privilege to come on stage after such fantastic research presentations. So I strongly encourage you to think of me not so much as a tapas, but a zesty little sorbet to cleanse your palate, because I'm really here to provoke and to make you think about something that might work. So before I go, can I just see a show of hands? How many lawyers in the room? Are you all going to get very angry? But that's okay. Hopefully I can explain to you why I still think this is a good idea. So, classic. So the whole idea of comic book contracts really comes from this bridging of the philosophical, which I think is very important, and the pragmatic, which I think we sometimes overlook a little bit in my trade. I'm not going to stand here and say that law has lost its way, although it's a very dramatic statement. But let's simplify it a little bit and say, perhaps in contract law, things have become a little bit too complicated. Is this not on? Can you not hear me back? Oh yeah, excellent, thank you. The issue is really very simple. So let's look at the philosophical. What is law, contract law in particular? What is it meant to do? Well, it's meant to nurture relationships and facilitate frameworks within people can work together in agreements that tell them how to behave, what expectations to have, and what outcomes to look out for. Really, that's the essence of what contract law is about. And what does it really do? Well, sometimes it works very well, and sometimes it really doesn't. Let's look at end-user license agreements as a fabulous example of that. Often referred to as the biggest lie on the internet. So we're going to do a little bit more interactive now. Please, as you're eating, discreetly put your hand in the air if you've ever bought anything online or clicked I agree online, right? Now keep your hands up if you did not read what you clicked I agree to. Now keep your hands up if you full well knew that that created a legal relationship. Now look around the room, please, everyone. Yeah. We are entering into contractual relationships that we don't even bother to read. And the interesting thing is, if I ask a group of lawyers this as a huge convention, we're going to get very similar results. Because despite what people say about us and all the jokes, we are very honest people. But it's not just end-user license agreements that are a problem. I have a number of good friends who I went to law school with years ago, who are now in prominent positions around the world in different businesses. And some of them work with counsel in large export companies, and they tell me a horrible reality. When they have a huge volume of trade, even large groups of in-house counsel don't have time to read their own contracts. They receive boilerplate agreements. They don't read the terms on the back. They send out their own. They hope for the best. And if there is a dispute, well, then we'll deal with it. Then what on earth are the contracts there for? So I think it's about time to admit that law needs some simplification. Now, I'm not saying everywhere. Some contracts work brilliantly. But we seem to have lost the plot. We are alienating people with our legalese that nobody reads, nobody understands, nobody likes it. And then there is this whole thing of trying to put more and more clauses into a contract, making them bigger and thicker and longer and more complex, because it is in our nature to try and think of things that may go wrong and stick it in there, even if it's highly unlikely that things will go wrong in this way. And I think there is something slightly wrong with that whole contracting ideology, that the very first thing you do when you enter into a sacred marriage of a contractual relationship is stick a 450-page prenup into someone's face and go, here's all the things that could go wrong. Let's deal with that before we have our first kiss. There has to be a better way. And so one night in Brisbane, as I was telling Robin about, I ran into an engineer. Now this was a wonderful engineer, he still is. He has a sense of humour, he's very clued in, and he likes to think outside the box. He gets a lot of stuff done. And he came to me because he needed a favour. And he said, Camilla, I need you to help me draft up a contract for the UWA makers, but you should know, I freaking hate lawyers. You alienate us, you distance everything, you make everything complicated. I just want anything simple, straightforward, and friendly. Oh, well, what do you want? He said, I need a non-disclosure agreement. You want a friendly non-disclosure agreement. An agreement that tells people they can't talk about stuff, but friendly. He goes, yeah, can you do it? Possibly. Now, it just so happened at the time I was very active in the proactive Scandinavian law movement, which was all about, and still is, about simplification, swim laning, streamlining contracts, cutting everything down to size, and making contracts for managers rather than for lawyers. And we were talking a lot about contract visualization and the power of images. And nobody can deny the power of images. I mean, I just sat right there on that chair and I stared at a storm which literally made me seasick. Now, you could talk about a storm for a long time and it wouldn't affect me, but seeing it, oh my gosh. So the power of imagery, really hard to dispute. But we lawyers, we've always worked with words. Why? Why don't we use other tools? Well, it's not traditional, it's not done, and it's not serious, it's not professional. Ah, come on, let's think outside the box. And so for the UWA Makers contract, we did. And we created comic strips for intellectual protection and for non-disclosure agreements. Just little panels. I can't show them to you because they're subject to a non-disclosure agreement. But from then, things kind of went a little bit haywire, in a good way. Now, I spent the last 20 years of my life becoming really, really good at one thing, international application of shared laws across different legal cultures. And now nobody wants to hear about that anymore. Now everything is comic book contracts this and comic book contracts that. And it seems the world was ready for this idea. At the same time, across the world, my friend Robert DeRoy has been working as a real practicing lawyer with similar ideas, also linked in to the proactive Scandinavian law movement. And he has just completed his first batch of employment law contracts that are entirely visual. Now, visual contracts, I believe, have a place in commercial law amongst professionals, but they also have a specific role to play with vulnerable groups. And Robert used these contracts in fruit picking industry. 650 plus contracts throughout the first fruit picking season. Easy to read, 8 pages, colourful, very clear. 2 important statistics come out of that. The first one is that the fruit picking company were able to reduce their training time from 4 hours to 45 minutes because the contractual expectations and the mutual obligations were so clear in the contract, it was really easy to tell people what to expect. And another thing, and perhaps the most amazing, after the fruit picking season had ended, for the first time in over 100 years, there were no employment law disputes. Why? Because everyone understood their rights. Nobody took risks and tried to go off for a day to a funeral because they suddenly realized, oh, I have a right to do that. So I just report it, no dispute. Cool. So I think those are really interesting statistics. Of course, they're not empirical enough for an actual review of how these contracts work because we're just talking about one set of contracts. But this is just the beginning. So we're currently working on contracts for a number of different interested parties. We've got a grant for Oricon to work with their employment law contracts, which I can say because they're happy to sponsor us. I'm also working for some departments for the federal government, and I can't tell you about that because then I'd have to shoot you all. It's the defense. So a number of state departments, and pharmaceutical companies, insurance companies, you name it. Everyone thinks this is a great idea. And now the law firms are beginning to come along saying, what kind of skills do our graduates need in order to be able to look at how to use these kinds of contracts in their work? So it's really very gratifying. So my latest talk on this was given at Financial Counselling Australia. And because I was given 37 seconds notice to give this talk, I have very cheekily relied on the same slides that I used for them. So this is just 3 slides. That's all you're going to get from me tonight, folks. 3 slides that embody the power of visualization. So what I'm going to talk to you now about is the National Hardship Register. Has anyone ever heard of the National Hardship Register? Yeah? Some slight nodding going on around the room and a lot of shaking heads. The National Hardship Register is a state-sponsored scheme which allows people who are in very serious debt to seek shelter either temporarily or permanently from debtors. It's a good idea for debtors because it means that they don't have to pointlessly pursue people who have no money and no prospects. And it's obviously a good idea for creditors because they get sheltered from the emotional persecution of creditors. So it's a nice document. But everyone in financial counselling who works with this, with a possible few exceptions who are excellent communicators, or they must be, but everyone else is saying that it's really difficult to get people to understand what this rather thick document, this contract embodies, and they're not really happy to sign it because they're very scared. They've signed one too many contracts. That's why they're in this position in the first place. So let me just show you what our amazing graphic illustrator Louis Silvestro, who I cannot praise enough what he's been doing. Okay, so these are still in draft, but because Louis has kindly signed intellectual property of all his work over to me, I can show you these. This is a man who's being persecuted by debt and he has nothing, hence the barrel. I'm not sure if the barrel works for you, but it works for a number of people. He's being henpecked by bills. And these are his prospects. Not good. No insurance payout coming, no inheritance coming his way. I love the toes. We spent so much time working on those toes. And this is the only bit of real colour in the whole 3 picture slides, which will ultimately become the backbone of the new National Hardship Register. The yellow umbrella, the National Hardship Register, protecting him from the rain. Now, it's interesting, we spent so much time talking about his face, whether he should be smiling or still miserable or just doubtful. It didn't work with the smiling. It looked like he was smirking. Ha-ha. Protected from debtors. That didn't work. But I think this is a good face because this is exactly what the National Hardship Register does. It shelters you from the rain, but it's not guaranteed to solve all your problems. So those 3 slides can help convince someone that this might be for them if they have no incoming prospects and if they feel persecuted by debt, they might seek shelter under the NHR umbrella. So I think these are quite powerful images. I hope that they prove a point. And if you want to see more, please contact me. We're currently trying to get a research syndicate up to do a lot more work in this space. So thank you.